Article 4 of the Constitution does not concern the powers of the three branches of the federal government, which are addressed in Articles 1 to 3. Instead, Sections 1 to 3 of Article 4 concern the relationship of the other states to each other, and Section 4 of Article 4 concerns political and security guarantees from the federal government to the states. In this unit, we consider Clause 1 of Section 2 of Article 4, the Privileges and Immunities Clause, which states that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Like the Dormant Commerce Clause, the Privileges and Immunities Clause serves as a restraint on state laws that bar out-of-state persons from access to local resources. It is different from the Commerce Clause in some important respects, however. First, note that the Privileges and Immunities Clause explicitly applies only to citizens. By its own terms, therefore, the Privileges and Immunities Clause does not protect any privileges or immunities of corporations. This can be a little confusing, particularly if you are generally familiar with the idea that corporations are considered legal persons for many purposes, including in recent First Amendment cases involving campaign contributions and free exercise of religion. Corporate personhood, however, is a legal fiction that does not apply to citizenship. We may allow corporations to influence elections through campaign donations, but corporations do not have the right to vote, for example. So, whatever economic privileges and immunities are protected by this clause, a claim under it can only be asserted by individual citizens, not by corporations. Second, the Dormant Commerce Clause restricts state and local regulation, but it does not restrict federal regulation. Under the affirmative powers granted to it under the Commerce Clause, Congress can, and often does, regulate in ways that inhibit interstate commerce or that benefit commerce in some states and not others. If Congress regulates in a way that disadvantages a state economically, ordinarily the only remedy is through the political process, that is, by seeking a legislative or regulatory change. The Privileges and Immunities Clause, however, may confer affirmative rights that Congress cannot waive. Third, while the Dormant Commerce Clause applies to all economic activity, the Privileges and Immunities Clause applies only to the exercise of fundamental rights. Fourth, the Privileges and Immunities Clause does not entail any market participant exception. United Building and Construction Trades Council v. Mayor and Council of Camden shows how these principles work. The provision at issue was a Camden, New Jersey city ordinance requiring that at least 40% of employees or contractors and subcontractors working on city construction projects be Camden residents. This ordinance obviously was designed to boost employment in Camden, which for many years had been in a condition of economic decline. The first issue the court addressed was whether the Privileges and Immunities Clause could apply to ordinances passed by a municipality rather than by a state. Justice Rehnquist, writing for the majority, disposed of this argument quickly. A municipality is a political subdivision of a state, and a municipality therefore cannot do something prohibited to a state by the Constitution. The court then considered whether the Privileges and Immunities Clause applies to distinctions based only on municipal citizenship. The clause itself refers only to citizens of the states. States and municipalities make economic distinctions based on municipal residents all the time. For example, municipal residents might get discounts on library cards, beach badges, public parking spaces, or a variety of other benefits not available to non-residents. But, writing for the majority, Justice Rehnquist held that the Privileges and Immunities Clause does apply to distinctions based on municipal residents. Does this then render things like discounted beach badges unconstitutional? Probably not, because of the intermediate scrutiny test that must be applied under the Privileges and Immunities Clause. The test is as follows. 1. Does the law burden one of those privileges and immunities protected by the clause, a fundamental right? And 2. Is the restriction closely related to the advancement of a substantial state interest? So what is a fundamental right under this clause? The 1823 case of Corfield v. Coryell noted that the category of fundamental rights under the Privileges and Immunities Clause may be comprehended under the following general heads: protection by the government, the enjoyment of life and liberty, the right to acquire and possess property of every kind, and to pursue happiness and safety. The 1868 case of Paul v. Virginia further noted that the Privileges and Immunities Clause protects the right of free ingress into other states and egress from them, that is, the right to travel freely between states. Here, under the first prong of this test, Justice Rehnquist concluded that the right to seek employment with private contractors working for the city or state is a fundamental right. Under the second prong of the test, Justice Rehnquist stated that to satisfy the closely related requirement, non-residents must somehow be shown to constitute a peculiar source of the evil at which the statute is aimed. Camden argued that it was suffering particular economic harms because out-of-state workers live off Camden without living in Camden. On this point, Justice Rehnquist remanded the case for further factual findings. In his dissent, Justice Blackmun argued that the Privileges and Immunities Clause should not apply at all to laws that discriminate based on municipal residence, because other political processes protect non-residents of municipalities.